Most people think of law as something that's made by lawmakers in advance of any particular case or controversy arising. In metaphysical terms, we could say that lawmakers make the law, and then the law exists. Positivists and natural lawyers agree about that. In this lecture, we'll consider another way of looking at it. Perhaps the law doesn't really exist until a court of law has rendered a decision. One theory that takes this position is the predictive theory of law. The predictive theory is attributed to a famous justice of the U.S. Supreme Court, Oliver Wendell Holmes, Jr. You were assigned an excerpt of Holmes' famous lecture, The Path of the Law, in which he sets out his predictive theory. The predictive theory is also associated with the school of thought known as legal realism, which emerged in the United States in the 1920s and 30s. It's not clear how many realists actually accepted the predictive theory, but Jerome Frank appears to do so in the assigned reading. Frank was a federal judge in the 1940s. The excerpt is from his book, Law and the Modern Mind, published in 1930. According to the predictive theory, a legal statement is true if and only if it accurately predicts how courts would rule. For example, the statement, Luis is the legal owner of the apple orchard on Highway A24, is true if and only if a court would actually rule in Luis's favor if his claim to the orchard were challenged. To make the statement about Luis's legal ownership is not to describe a pre-existing legal state of affairs, according to the predictive theory. Rather, it's to make an educated prediction, like a prediction that the Green Bay Packers will have a winning season. The predictive theory received devastating criticism from H.L.A. Hart and others in the past century. If legal statements are merely predictions of judicial behavior, then there can be no such thing as a judicial mistake. Whatever a court decides simply is legally correct by definition. At least this is true of the highest court that has jurisdiction in the case. A decision by a lower court can be overturned on appeal and thus deemed mistaken, but when a high court rules, we can't criticize the ruling as legally incorrect. We can always object on moral grounds, but legally speaking, the high court is always correct, according to the predictive theory. But how could this be? Don't judges on high courts make mistakes, as everyone does? Judges can misread statutes, ignore precedents, reason fallaciously, and so forth. The predictive theory seems unable to account for these facts. The predictive theory also can't account for what Hart calls the internal point of view. According to the predictive theory, to say that littering is illegal is simply to predict that a court will uphold a conviction for littering. But the proposition that littering is illegal must be more than this. Individuals can treat the fact that littering is illegal as a reason not to litter, even if they don't know there's a penalty for littering or don't care about the penalty. They can, in other words, take the internal point of view with respect to the law. Not everyone is like the so-called bad man described by Oliver Wendell Holmes. The centrality of the internal point of view becomes even clearer when we consider the perspective of judges. It's impossible for rational judges to treat the law as merely a set of predictions of judicial behavior. A judge isn't trying to predict his own behavior, he's trying to decide what to do. The predictive theory can't account for the function of law in guiding judges in their decision-making. There are, however, important questions to be asked about judicial reasoning. Judicial reasoning is legal reasoning, which is reasoning that aims to reach legal conclusions. These include conclusions about a party's legal rights, powers, and duties, as well as conclusions about the validity of particular legal standards. Legal reasoning is the characteristic kind of reasoning you find in published court opinions and briefs submitted by parties to a case. It's the kind of reasoning that a lawyer offers in order to convince another lawyer that a certain conclusion is legally correct. Lawyers sometimes say that the purpose of studying law is not so much to learn the law as to learn to think like a lawyer. They mean that studying law teaches competent legal reasoning. The rest of this lecture examines how lawyers, judges, and other public officials reason about the law and defend legal conclusions. Let's begin with a question. What goes on in a judge's mind when she decides a case? We'll use the example of a trial judge in a hypothetical tort lawsuit. The judge hears the following evidence. Defendant agreed to walk a friend's pit bull. Defendant took the dog to a park without a leash, and the dog proceeded to bite plaintiff, causing minor injuries. Plaintiff sued defendant for medical expenses and compensation for pain and suffering. What thought process leads the judge to her conclusion, whatever it turns out to be? One suggestion is that the judge first arrives at a determination regarding the facts of the case. She determines, based on the evidence, what the defendant did and what caused the plaintiff's injuries. Then she identifies the legal rules that apply to such cases. These are particular rules of tort law, which she might know by heart or need to research. After identifying the applicable legal rules, she applies them to the facts and reaches her conclusion. She decides whether defendant committed a tort against plaintiff, and if so, what remedy the law provides. In this little story, legal reasoning is a process driven by rules. The idea that legal reasoning is rule-driven has been highly influential in the history of legal philosophy. Some have claimed that legal reasoning is deductive, akin to logic or geometry. Some characterize legal reasoning as mechanical, meaning that no distinctively human judgment is required. The suggestion that legal reasoning is deductive or mechanical has some important implications. It implies that there's always at least one legally correct answer to a legal question, as well as multiple incorrect answers. There is, in fact, a way to represent much legal reasoning as deductive. Consider the following argument. Anyone whose negligent conduct causes injury commits a tort. Taking a pit bull to a park without a leash is negligent. Dirk takes a pit bull to a park without a leash. Dirk's conduct is negligent. Dirk's negligent conduct causes the pit bull to injure Pam. Therefore, Dirk commits a tort. This argument is deductively valid, at least if we interpret it sensibly. If the premises are true, then the conclusion must be true. Insofar as this argument constitutes legal reasoning, there's a form of legal reasoning that is indeed deductive. Of course, the legal process involves non-deductive forms of reasoning in addition to deductive forms. Consider the role of a fact finder in a trial, a jury, or in a bench trial, the judge playing a fact-finding role. Fact-finding is not deductive. Jurors hear evidence and testimony from witnesses whose credibility they must assess. This is not a purely deductive process. Then jurors must formulate hypotheses about what happened, again not by deduction, but by observation and inference. So fact-finding isn't a purely deductive process. But what if we take certain facts as given, as in the argument above, where the facts are stipulated in premises 2 through 5? We can take the legal rule stated in premise 1 and apply it to these facts. Then we can deduce a legal conclusion. Dirk committed a tort. So deductive legal reasoning is possible if enough facts are established. An interesting question, however, is to what extent judges actually think this way. Published judicial opinions often present arguments in deductive form, but do these documents accurately reflect the judicial reasoning process? Do judges really begin with facts, identify the applicable legal rules, apply rules to facts, and reach conclusions? Many writers have doubted the accuracy of this simple picture. According to the legal realists, judicial decision-making is fact-driven rather than source-driven. The stereotypical realist believes that judicial reasoning proceeds as follows. First, a judge hears the facts of the case and forms a judgment about which party ought to win. This judgment is not necessarily based on legal rules. The judge may not yet have even considered any rules. Imagine a judge hearing Pam's case against Dirk. The evidence convinces him that Dirk brought his pit bull to the park without a leash, and that the dog subsequently bit Pam. Just on the basis of this evidence, the judge may conclude that Dirk has wronged Pam. He now wants to rule in Pam's favor, assuming that he wants to right the wrong. However, he knows he's expected to write an opinion that supports his ruling on the basis of legal standards. So he consults legal rules and tries to write a legal argument that supports his conclusion on that basis. Rather than allowing his conclusion to be dictated by legal reasoning, the judge allows his reasoning to be dictated by his prior conclusion, according to the realist. Realists believe that different judges respond to the facts of a case differently, depending on their individual psychologies, personal backgrounds, social class, and political beliefs. These influences often work subconsciously. Different realists emphasize different factors. Some emphasize the effects of a judge's personality. Others emphasize his political commitments and allegiance to his social class. But all realists agree that judicial decisions are not dictated entirely by legal rules. In their heyday in the 1930s and 40s, legal realists also championed the idea that law should advance the purposes of a developing society, and that judges have an important role to play in promoting the general welfare. According to many realists, judges can, do, and should make policy from the bench. Many realists urged courts to be more candid about their role as policymakers, and to employ the latest social science in their effort to make good policy. This dimension of realism survives to this day in various forms, including the enterprise known as law and economics.